Good day to you. This is Graham Paddock with another Paddocks Club video tutorial. This week we're going to talk about fines and penalties for arrears in community schemes. And the first thing we'll look at is, well, what are we actually talking about? While a sectional title scheme or an HOA has no inherent power to punish its members, it isn't unusual to find that the rules or the other governance documentation that applies includes provisions enabling it to fine or otherwise penalize defaulting members to encourage them to abide by their obligations under the law or those governance provisions. Right, so where will you find those provisions? For schemes, the penalty provisions must be in the scheme's actual rules. For an HOA, they are found in the Memorandum of Incorporation, or the articles of an HOA, but they may also be found in rules made by the members or executives of the HOA. So slightly different situations in each case. What type of penalties can be imposed? Well, a penalty might not necessarily have to be financial. Owners in arrears with their levies are sometimes deprived of their voting rights, or perhaps more of the other rights of membership. Penalties may in practice involve the withdrawal of rights to use non-essential commercial facilities. You can't use the swimming pool because you haven't paid your levies. With a proper rule, with a proper provision in your articles in the MOI, that is possible. But in many cases, where these penalty provisions do exist, they provide for financial penalties in the form of fines. Is there an automatic right of appeal if somebody does impose a fine against you? Well, the governance documents may or may not provide for an appeal process. A court won't likely interfere with the internal arrangements and decisions of a scheme or an HOA, but if there is no internal appeal procedure, an owner is entitled to approach the High Court directly for relief if he or she feels that the fine penalty is excessive or has been unfairly imposed. When the Community Scheme Ombuds Service Act comes into effect, owners will be able to appeal to that service. What are the fundamental requirements for penalty provisions? Perhaps this is the most important aspect. Firstly, there are such requirements for and limits to the rights of a scheme or an HOA to impose fines or penalties on those members, and we're going to summarize these below. They fall into three categories. You'll see reasonable amounts, legitimate purpose, and fairness in procedure. Let's look at reasonable amounts. The fines or penalties must be reasonable in their actual amount. This doesn't mean that they must be very small. On the contrary, they may be quite substantial. The courts have upheld some substantial fines, but it does mean that the amounts must be proportionate to the purpose they are imposed to achieve. A fine that is disproportionately high can be reduced by a court in terms of the Conventional Penalties Act. Let's look, secondly, at legitimate purpose. Firstly, penalties or fines must be linked to the scheme or the HOA's enforcement of one of its legitimate or rightful interests. An example of a penalty that serves as a disincentive to late payment and may also be designed to recover the costs associated with initial levy recovery procedures is a late fee. That's payable, if in terms of some rules, automatically when a levy becomes overdue. The HOA certainly has a legitimate interest in ensuring that owners pay levies by the due date, as does any sectional title schemes. Examples of fines that would not be recoverable will be those imposed to punish members or who have, for example, complained about the scheme or the HOA or scheme's management style, or asked questions that suggest that the security staff may be involved in wrongdoings. These are actual examples I give you, which I have said to people, you can't impose a fine in those circumstances. The scheme executives don't have the right to use fines to stifle member comments or complaints. That's not one of their legitimate purposes. Let's look finally at fairness in procedure. A fine must be applied fairly, but the governance documents may exclude certain aspects of what are normally considered to be due process and procedural fairness. The test for fairness may vary from case to case. In the case of an alleged wrongful action, the process will normally include consideration of all the relevant circumstances and giving the accused member an adequate opportunity to argue and cross-examine witnesses. But in the process in dealing with just what is a late levy payment, then due process may be much more limited. It may just be an initial notification of the levy, a reminder that the levy is overdue, and an obligation to retract the fine if the member can show that the levy was in fact paid on time, but for some reason didn't reflect on the HOA's bank records. I hope that this has been of assistance to you. And I look forward to chatting to you about this and other issues in the Paddocks Club discussion forum.